When you die without a will, you die intestate, leaving your estate to the direction of the state's intestate succession laws. Intestacy proceedings leave your family with little to no say over how your assets are distributed, and it can significantly lengthen the time it takes to ultimately distribute your assets to your heirs. To avoid the hassle and save your family the additional time and cost, it's essential to have a last will and testament.
Minors cannot own property, so it makes sense that they don't have the capacity to gift assets either. If a minor drafts a will, a probate judge will invalidate the will. Testamentary intent is the intent to give instructions for what will happen to the testator's property when they die. Testamentary intent can be difficult to prove or disprove if someone contests the will, though it tends to go hand in hand with undue influence. Self-proved wills avoid the hassle of a potential court appearance by having the witnesses and the testator sign the will in the presence of a notary public. A notarized will is far more likely to overcome contests in probate court and is the better route when possible. If you're drafting your will with the help of an attorney, there should be a secretary or other employee at the firm who is notarized to make this step easy. When naming a guardian for minor children, it's smart to list 1 or 2 backup guardians in case the primary guardian is unable to assume the responsibility. In the absence of a chosen guardian, the court will need to appoint a guardian and/or conservator, possibly leaving your children in the custody of the state for some time until a qualified family member or friend can be appointed. The executor is the personal representative who is authorized to handle your estate when you die. An executor will be tasked with gathering your assets, settling your liabilities, distributing your assets, and ultimately closing your estate. Considering the weight of this responsibility, it's important to choose an executor who is competent and trustworthy. Distributing assets. When it comes to assigning assets to beneficiaries in your will, you can only address assets that are subject to probate. This includes individual bank and brokerage accounts, real property owned individually or as tenants in common, and personal property, such as vehicles, art, collectibles, jewelry, weapons, and furniture. Wherever possible, try to assign specific assets to specific people. It's also a good idea to include a catch-all clause in your will to ensure nothing is accidentally left out. For long-term peace of mind, contact us to set up a consultation today. We look forward to helping with your will and other estate planning needs. Call our Arizona estate planning team at 480-660-3938 to discuss your case today.